The Republican nominee for Attorney General says the state Supreme Court should invalidate the controversial Safety Act, which abolishes cash bail as of January 1st, among other things. He quotes the Illinois Constitution. All persons shall be bailable by sufficient sureties, except for offenses where the proof is evident or the presumption great. He claims the new law is not too soft, but too harsh.
There's going to be circumstances that people are going to be held in jail more often sometimes than when they may have been before. That's the reality.
All right, so explain that. That's the first time I've heard that one. Up first, Thomas DeVore, a downstate lawyer who filed dozens of lawsuits against pandemic public health orders. DeVore now opposes incumbent Attorney General Kwame Raoul's efforts, discussed on this program recently, to get the proposed Equal Rights Amendment, which appeared to fail 40 years ago, officially declared part of the U.S. Constitution. Let's get fired up.
The conversation today in 2022 is not even the same. I don't even think today in 2022 we can agree on what defines a woman. So the Attorney General is just pandering at this point in time. That amendment's not going anywhere.
So were you saying a moment ago that setting aside the time limits and the procedures, the Equal Rights Amendment would be a good thing to be part of the Constitution? No discrimination on the basis of sex?
Well, I think not discriminating on the basis of sex. I have two 19-year-old daughters, so we all agree that we don't want discrimination based on sex. What I'm saying is that amendment in and of itself, I don't think achieves the goals that would need to be achieved today, 50 years later. I think, defining rights based upon sex is not as clear of a conversation as it was maybe in 1972. So that amendment's not necessary in order to achieve some of the things that we've already achieved since that time.
So you've told me that you're on a Safety Act tour. You're discussing it all across the state. Supporters argue that it simply puts into Illinois law what's in the U.S. Constitution, which is that you're innocent until proven guilty, and that unless there's a good reason, you should not be locked up before you've been convicted.
Okay, if it was merely that simple, I would kind of chuckle. It's not that simple. Everyone under the Illinois Constitution has the right to bail except for very narrow circumstances, okay? And we should not have money alone being a reason that someone's in jail. That's absolutely, I agree with that. But this Safety Act doesn't remotely come close to that. It actually has a counter effect, and there's going to be circumstances that people are going to be held in jail more often sometimes than when they may have been before. That's the reality.
All right, so explain that. That's the first time I've heard that one. Tell me, how can that be?
Because there's two extremes in this bill. You're either going to be let out on your own recognizance, or you're going to be held without any opportunity to be released. Those are the two extremes under this statute. So before, when a judge was not satisfied that your promise alone was sufficient for you to comply with pretrial conditions, the judge could use financial component to incentivize compliance. They're trying to strip that away. So now when a judge is facing the position to where the promise alone is not enough, the judge's only option under this statute is to detain them until trial, which violates people's constitutional rights. So if you have a poor man, let me make sure you understand this, Mike. If you have a poor man who the judge says your promise alone is not sufficient for me to believe you'll comply with the pretrial release conditions, before the judge could at least offer some type of cash bond to seek compliance. If you take that away, the judge is only left with holding them in jail until their trial. So the judge is going to let them back out on the street based on their promise, which he doesn't think is sufficient, or he's going to detain them permanently until trial.
Well, listen,
not only is that a violational problem of the Constitution, that defeats the very purpose of which they say they were trying to pass this law.
So I don't know if you've ever sat at 26th in California through bond court. I have on a number of occasions, and I've seen the judges and the completely overwhelmed assistant state's attorneys deal with violent felonies, in some cases in less time than it takes to make a ham sandwich. Right now, these prosecutors are going to need more resources in order to make the case to detain somebody. And that's the problem. That's the biggest problem I see, is that we don't have enough assistance. Now they're going to have to be screening hours and hours, potentially, of body-worn police video, dash cam video. I mean, who's going to do that in order to make the case to detain somebody?
Well, Kim Foxx has already said she doesn't have the resources, and that's right. Kane County told me they need 50 more prosecutors to do this.
DuPage County is hiring 30 more prosecutors.
Yeah, to have these hearings, and the threshold in those hearings is complicated. But I want to make sure that going forward, you are a part of having this conversation, because again, when I'm looking at this bill, I look at it from the public safety perspective and what that's going to cause, and also from the rights of those accused of a crime. They're two independent conversations, and they're not contradictory. When you have the governor of the state of Illinois on TV saying that we're going to use this law to detain people who have allegedly committed violent crimes, he's openly suggesting we're going to violate the constitutional rights of those accused of a crime. Because whether people like it or not, almost in all circumstances, someone accused of a crime has a right to bail. They have a right to be released pending their trial. And so when we have this statute that's saying, well, if the judge is not going to release you on your own promise, he's just going to detain you. I'm sorry, Article 1, Section 9 of the Constitution of the state of Illinois says you cannot do that to people. And the civil rights lawyers...
We have for hundreds of years. We have for hundreds of years. People who, murderers caught with the knife embedded in the victim, they haven't been released.
You're not listening to me. Under Article 1, Section 9, it lists which crimes someone can be detained without offering bail. Murder is one of them. Attempted murder is another. But all of these categories of offenses in this new statute lists numerous crimes for which the Constitution of the state of Illinois says you cannot detain them without offering them some type of bail. That's what it says. So again, leave murder out of it, attempted murder. Article 1, Section 9, if you go read it, includes those categories that you just mentioned.
All right,
but whether we like it or not, mere domestic battery, which is a serious crime, absent some unique circumstance, the judge can't detain them without offering any bond whatsoever. It violates the Constitution of the state of Illinois.
Well, now the governor wants to say, as you said, he wants to amend it, not end it. Your friend Darren Bailey, the nominee for governor, has called for repealing.
I know Darren, and I don't call him an unfriend, but maybe, connecting me to Darren, my campaign is independent. This law, not only does it have a lot of other problems, if you read the Hemingway case and the Bailey case, no connection to Darren, from 1975 and 1995, they both unequivocally say that the legislature cannot create categories of crimes and call them detainable or non-bailable. The legislature doesn't have that authority, and to the extent they've done that, they've violated the separation of powers. Those aren't my words. Those are the words of the Illinois Supreme Court. So all of these categories that they've created in this law under Section 6.1, to the extent they're broader in scope than those listed in the Bill of Rights, it's unconstitutional. The legislature can't do that. And none of these attorneys have yet pinned that down specifically in this lawsuit. If someone's accused of committing a bunch of these offenses in these 7 categories, that the court can potentially detain them without offering any bail, it's unconstitutional, and the civil rights claims are going to roll through this state.
So, Mr. DeVore, you mentioned Kim Foxx earlier. At this summer at Republicans' Day at the State Fair, you suggested that you might find a way to prosecute Kim Foxx. What did you mean by that?
What I'm talking about is a general proposition about politicians in general, including states' attorneys. If they get to the point to where they're derelicting their duties and engaging in official misconduct, which is something significantly more than just exercising prosecutorial discretion, that is something that be considered. To just arbitrarily decide that I'm going to not prosecute anybody for felony theft unless it's over $1,000, when the statute doesn't say that. Whether or not those rise to the level of misconduct by a public official is a conversation to be had. And I'm not saying I'm going to, I'm just saying that we as people have to have those conversations. That's all I'm saying at this point.
All right. The Republican nominee for Attorney General of Illinois, facing incumbent Kwame Raoul, Thomas DeVore. Thanks very much for joining us.
Yes, sir.